Morning, Chief Justice.
How are you?
Fine, how are you?
I'm well, thank you. May we start?
Yes.
Okay. You are an advocate
Yes, I'm an advocate.
and you've been practicing in such since 1989.
Yes.
Okay. You hold three degrees, a BA, majoring in economics and psychology, which you obtained with distinction, an LLB cum laude, and an LLM in tax law with distinction.
Yes.
And the
Chief
first
Justice.
degree you obtained from the University of Cape Town,
Yes, Chief Justice.
and the other two from the University of Witwatersrand.
Correct, Chief Justice.
Right. So, what kind of practice have you been running for this past 36 years? What kind of work do you do?
My practice was generally commercial work, and I intentionally tried to steer away from matrimonial work because I knew that it tends to pigeonhole women at the bar. And I continued until I was offered the opportunity to go to the State Capture Commission. And I spent 2.5 years at the commission
As an evidence leader.
as an evidence leader. And then when I left the commission, there was a lot of offshoot work from the commission, particularly work from the National Prosecuting Authority, because I'd been in the law enforcement agency work stream. And we were asked by the ID and the general part of the National Prosecuting Authority to assist with several aspects following upon the commission. And that filled a lot of my time after I left the commission. But what I also found is that when I'd left the commission, I was substantially older, and my commercial practice before I went to the commission had been to be a senior junior in commercial matters. But I was now actually found myself being too old to be briefed as a junior in those matters. I stopped getting those briefs. But I also stopped receiving the more junior commercial work because I was regarded as too expensive, and I also wasn't a silk. So what then happened with my practice is I started to get other work from the state attorney, work that was not related to state capture, but was also generally not commercial work. I started to do very different work with the state attorney. And what I found is that I would then began to be able to command juniors. I was able to ask the state attorney to appoint juniors for me. And in the last few years, I've acted with a number of juniors, all of whom have been black juniors, except for one colored junior. So the nature of my practice is really, it's changed enormously. I'm actually doing quite a lot of labor law, which I've never done before. I've done a lot of constitutional law. I had done a lot of constitutional law before because I'd been involved in a lot of reviews, particularly with tender irregularities and corruption. But I find myself with a very different practice, and I've actually quite enjoyed it because I've been more self-sufficient, and I found that the state attorney has allowed me to command respect.
You've also practiced as an arbitrator.
Yes, I've acted as an arbitrator on numerous occasions. I've also been appointed by the Bar Council to act as an arbitrator. And I've also, in the course of preparing for this interview, the acting judge president asked the candidates to have a look at how many judgments we'd written, in which fields we had written those judgments, and also in which courts we had sat. And I actually determined that I have acted for 31 weeks. And in the course of that time, I've actually written 49 judgments. So although the ones that are appearing on SAFLI, it seems to be about 29, I've written 49 judgments, and I've written them in a huge array of fields. So I've had a lot of experience acting as a judge. I've learned a lot, and I really enjoy the experience.
Your acting stints have been here in Gauteng.
Pardon?
Your acting stints have been in this division, in the local division.
Yes, they have. So all my acting stints have either been in Johannesburg or in Pretoria.
In Pretoria. And have any of your judgments been reported?
You know, I found it confusing because for me, when you say
reported is in the law reports, not on SAFLI or any online platform.
Exactly. So for me, the one that's been reported is the one, I think it's Mbeki Manganese, or I can't remember the exact name of it. It went to the Supreme Court of Appeal. That's the only one that I'm aware of that's reported in the law reports.
Why have you never taken silk, if I may ask?
That is a good question. I have applied for silk, and interestingly, one of the objections to allowing me to be conferred with silk was that it was well known that I had aspirations for judicial office. And it was put to me, but if we give you silk, you are just going to go straight to apply to go to the bench. And my answer was that I don't see why that would deprive me of being afforded silk. And the response that I got was, it does, because you are going to be appointed silk, and then the bar itself is not going to benefit from your having been a silk. And for me, I don't think that's a valid response, because honestly, it's in the interests of the bar to have good judges on the bench. And it's also in the interest of the bar and the judiciary to have people who go to the bench appointed silk if they deserve it, because it lends to the gravitas of the bench. And I know there's a kind of moratorium that if you want to go to the bench and you are a black or a white woman or a black male, you're eligible if you're not a silk. But if you're a white male, you must be a silk. But the truth is that where someone is deserving of silk, we don't want to be elevated to the bench on the basis of a moratorium. And I do believe that I'm deserving of silk, and I think if I applied again, I would get silk. But
so did you apply only once?
No. I think I applied on 3 occasions. And one of the issues that was also raised, which I just wanted to add, is that I hadn't acted sufficiently with juniors. And what I tried to explain that is that at that time, the nature of my practice was such that I was briefed as a senior junior in very large commercial arbitrations, but I was not briefed independently. And if I can tell you how that happened in my practice, because I think it is important to understand why it was that it became difficult for me to act with juniors and to be briefed with juniors. And I was building up a very good practice for myself when my children were young, but I worked with my first two children, all three of my children, until the day before my babies were born. I was in court with this big pregnant stomach. But after my son was born, I thought I've missed out so much of my life with my children. I'd like to see if I can try and practice from home. So I applied to practice from home, and I was granted permission to do that. But unfortunately, what I found is that when you are a woman at home at the bar, you're kind of out of sight, out of mind, and also people stop taking you seriously. And if you're a commercial lawyer, but people think, well, she's not available, she's fetching her children from school, or she's doing this. So if in effect, my practice diminished enormously during that period. So after that, it was a period of 2 or 3 years, I decided that it wasn't feasible for me to practice from home. I needed to take chambers again, and I joined Group 1. And when I joined Group 1, before I joined Group 1, I'd looked at the kind of nature of women at the bar, and what I realized is that to try and be taken seriously and receive good work, it was very important to be specialized. And so I decided what I'm going to do is I'm going to register. I was into my 40s, and I'm going to see if I can specialize in tax law. And I registered, I joined Group 1, I was granted, afforded a pupil, and before I could move into my chambers, I had a massive thrombosis in my brain and a stroke. And that precluded me. I had to sublet my chambers, tell the Bar Council I can't take the pupil, and I had to go and recover for a year. And somehow at the end of that year, with very little time, I had to get a thesis in, which I did. And the next year, I had to write an exam, which I did. And then after that, now you can imagine, I've been out of sight, out of mind for another 2 years. I went to Group 1, and I didn't have really any attorneys who were briefing me at all, and I was now in my 40s starting again. And so I was reliant for my work on the kindness of senior members of my group who brought me into matters that they were involved in. And then what happened from there is I got briefed in more and more complex matters, which in a way was very good for me, but also to my detriment, because they were not matters where the attorneys felt that they would brief me on my own. And the attorneys who did brief me, I had to draw all the papers in the matter, and when it came to going to court and there was a silk on the other side, then, and I'm telling you, it didn't happen to me once, it happened to me on several occasions. In every one of those matters, the client and or the attorney said we need to bring in a white male silk. And so I never got to actually run those matters, and it was incredibly frustrating for me. But when after I had applied for silk and I'd been told I didn't have juniors, and I was trying to explain that it was very difficult for me, the very first brief I got from the state attorney, that I had an opportunity to bring in a junior. I spoke to the state attorney and said, can I please bring in a junior? This matter is big enough, it's complex enough to have a junior. But unfortunately, the department I was acting for said they were not going to pay for a junior. So what I did is I approached the Bar Council and I asked them if they could assign a junior to me, which they did. And I paid for that junior. And it was a big matter, and I was actually very generous in the amount that I paid him because I was told that there was a certain rate that I would need to pay him, and I paid him twice that rate.
And who was this junior? Was it a woman? Was it a man? What was their race?
It was a black man. But I had no choice. The Bar Council assigned that junior to me, and the idea behind it is that I think people are only eligible if they are baby juniors at least less than 5 years at the bar. But I think it's generally people who've just come to the bar to try and assist them in meeting, as he did, the state attorney through me, and that helps his practice get going. And after that, as I said, since then, and since I've not been only doing estate capture work with the state attorney, in all the matters I've been briefed with black juniors.
I interrupted you as you were saying you believe that if you applied for SIL today, you'd get it. What's stopping you from applying?
Because in my mind, I didn't apply last year, because I was hoping that I wanted to apply to come to the bench. And then I did apply, and the current Deputy Chief Justice called me, and he said to me, I am not going to. The reason I didn't make the shortlist, he explained to me, is that I hadn't acted enough since I'd left the commission. And he asked me to please come and act for a further periods, which I did. So I acted for a month at the end of November, and then July, August this year, I acted for another month. And with those additional 8 weeks, I've now acted for 31 weeks.
Okay, you list your involvement in the Human Rights Subcommittee of the Bar Council.
Yeah.
The Briefing Patterns Subcommittee.
Yes.
And the, the Transformation Committee of Group 1. What do these committees do?
Well, the Transformation Committee when I was there, what we wanted to try and achieve, and it's a matter that I tried to propose, is to see if we could introduce a clerking system, something similar to what they have in England, so that if a group gets work, attorneys will phone the group, that they'll speak to either the administrator or clerk is in that group, and particularly for a divorce, unopposed motion, noting judgments, that kind of work, there would be a pool of people who could be recommended, and that the group would then say, okay, you've had your turn, it's this person's turn, it's that person's turn. And the other was but that didn't really find favor. It wasn't seen as a very good idea. When I was with the Briefing Patterns Committee at the bar, it wasn't my idea. They had a very good idea, and that is in the unopposed motion court, and particularly the default judgment court, which makes up an enormous amount of the matters that appear, the matters that are before the judges in those courts. and that was to approach the banks themselves. And there was approach to Standard Bank, I think, and they actually were very amenable. And a list was provided of a whole lot of juniors who were previously disadvantaged juniors, and they were asked to try and brief, giving people a chance all on that basis. And the idea is that it would be run all over the country. But ultimately, it was quite difficult to police that system. And I remember we had a lot of frustration with that. There was also a lot of the juniors, like middle, senior black juniors on that committee, who found it increasingly difficult that they didn't have skills, and that there was no way for them to get skills unless they got the briefs. So they needed, and they didn't just need the junior briefs, they needed to take that, not junior briefs, I mean the unopposed motion court kind of briefs. They needed to be able to take that step that they would be briefed in their own in the magistrate's court and this type of thing. So we also then engaged with the state attorney to try and give lists of people, of previously disadvantaged people, see if they could brief on that basis. But I remember Standard Bank came back to us and they had very positive kind of response saying, this is how many black juniors, this is how many whites, this is how many coloreds, this is how many years they had experience, this is how many briefs they got. But after I left that committee, I'm not sure how far that has got and whether it's been persisted with. But what I have seen recently now is I've seen that when I mentioned earlier that I thought that it's very important for people who try and build a career at the bar to try and specialize. It's very difficult to compete as a jack of all trades. So I've seen that what AFTR's doing is they're starting to run workshops, and I think I saw that there's a workshop that was supposed to be run, I think it might have been cancelled, but on competition law. And they're doing that in a number of fields. Now for me, that's probably the most productive way of trying to transfer skills and equip juniors to deal with a whole variety of things and then take that leap. Because if you get a brief in competition law and you know nothing about it, you've got to spend so much time reading and working it up that you can never charge for. But if you can attend a couple of courses, when you get that brief, you're already halfway there. So I think that's a very important initiative that I'd never thought of that, but I think it's very important.
Any such initiative?
Have I been involved in that initiative?
With that kind of initiative?
No, I haven't. What I did offer my services to the advocacy training at the bar for year after year after year. And at the time that I had applied for Silk, I actually mentioned that I keep putting my name forward, but nobody seems to respond to me to invite me to do it. And when I was finally invited to do it, it was when I just joined the commission. And so I couldn't do it. But what I have done is I've been teaching the pupils for the South African Independent Bar to help them with their exams. And I've done that 2 years in a row. So it's outside of the bar, but I've assisted those pupils.
Okay. Thank you, Advocate Wentzel. AJP Network.
Thank you, Chief Justice. Good afternoon, Advocate Wentzel.
Good afternoon, Commissioner.
When I look at your work schedule, you haven't done a criminal trial.
Yes, that is correct.
Should you be appointed, are you aware that such matters can be allocated to you? And as a judge, criminal trials are not exclusively for certain judges.
Acting Chief Justice, I am aware of that, and I know it was a comment that was raised, I actually think by aft. But you will see in the schedule that I prepared for you, I think for 3 weeks of my allocation, I sat on criminal appeals. It is different from running a criminal trial, but obviously through no fault of my own, in my acting appointments, it's the discretion of the Deputy Judge President to allocate where you're going to sit, and I've just never been allocated in the criminal court. But what I can tell you is that I've sat for several weeks in civil trials. I know criminal trials are very different. There's a totally different onus. A whole lot of different principles apply. Never ashamed to say to counsel, and often at senior counsel, I'm not familiar with this law. Please go slowly with me. Don't assume I know anything. And in that way, I am taught in a way by the counsel. And then afterwards, I will always go look up the law further, read all the cases I'm referred to, research if there are any other further cases that I have not been referred to. And then after that, I'm more familiar with that area of law, and the next time I get a trial or an opposed motion, I'm in a different position. And I would just take exactly the same approach to criminal matters. I would ask assistance from fellow judges. I would ask assistance from counsel in front of me, and I would make sure that I did justice to whoever it was or whoever the accused people it was who appeared before me. Because obviously criminal law is very, very serious because people's liberty can be taken away from them. It's not the same. Well, it's terrible to lose money and to lose your house, of course. But if you've got a prospect of being incarcerated, that's very, very serious, and I would take that job very seriously. But I do believe that I have the intellectual capacity, the competence, and a sense of justice and fairness that would allow me to run those trials in a fair and proper way.
Are you aware that when you are in a criminal trial, you've got the benefit of asking for assessors to help you?
Yes. And I would certainly do that.
Okay. Thank you, Chief Justice.
Fully covered, Chief Justice. Thanks.
Minister.
Thank you very much, CJ. Good afternoon, Advocate Wentzel.
Good afternoon.
The first one, I want to check. In your questionnaire, you don't seem to have any community work reflected or mentoring program or training program. Are you able to share if you are involved in any of those?
I tried to address that earlier with the Chief Justice to explain that I did try to put myself forward to do mentoring programs, particularly with the advocacy training. And I have taught the pupils from the independent bar. What I've also done is there's an initiative in Group 1 where and it only involves females, but it's an initiative where the senior female members of the group are each year paired with a new junior in the group. And I've participated in that program ever since it has started.
Okay, thank you. The second one, it's relating to your response to CJ.
Yes.
As he was talking, she was asking you some question. You made reference to say, and I'm trying to understand it better perhaps. You made reference to say that when you came from the work of the state capture, you were no longer regarded as a junior. It made it difficult. I couldn't understand what you were trying to communicate there. So you became a senior advocate. You wanted to remain a junior. That's what I'm trying to understand there.
Yes, yes, I'm sorry for the confusion. What I meant is that so when I went to the State Capture Commission, I was about 55 years old. And at that stage, I had been a senior junior in big commercial matters where, and I'd left a lot of those matters halfway when I joined the commission. But when I got back, what I found is even those briefs I wasn't getting anymore. And that's because I was now 3 years older. I was 58 and approaching 60. And I found that I was actually just regarded now as too old to be a junior, even though it was in a senior matter. And I don't know why those 3 years made such a difference, but it did. But at that stage, I had already been out of my practice for 3 years. So I didn't have a set of attorneys who are now immediately briefing me on my own in those matters. And even when I did, as I said, what was happening to me is I was being told, no, we need to have a silk. And black males were brought in to lead me. So I just was in between, and that's what I tried. The frustration I tried to explain to the silk committee is, you're putting me nowhere because I'm not getting the work because you're not making me a silk. But I'm too senior to be a junior, so I can't do junior work. So it was very, very difficult. And actually, the work I started getting from the state attorney is what rescued me.
Okay, and at that time you were also doing the work for NPA.
Yes.
If I may check, during the time you were doing the work for NPA, were you also acting as a judge?
No, I didn't act as a judge because of the commitment that I'd made to the NPA. And I had wanted to, at that stage, I've always wanted to be a judge. Ever since I've acted, since I was 2015, I've always wanted to be a judge. I love acting as a judge. I feel it's the one place that you really can make a difference. So that even though it is not a pleasant exercise reading 80 default judgments for one day in court, the truth is, particularly now with the rules relating to the execution of property that is somebody's primary residence. The new rules require reserve prices to be set, but also giving judges an enormous discretion to allow leeway. And also leeway to have time to sell a house privately rather than at an auction with a sale and execution where you're going to get far less at a forced sale. And it's in a lot of matters also where you appear as a judge and there's an unrepresented litigant. And they ask for time and advice as to where do they go to get help. And I've often asked the counsel on the other side, please go provide assistance. We're going to give time. These people must be represented. It gives me, just gives me a sense of fulfillment that you have power to do justice. The other part I
Okay.
love is.
No, I was asking if at the time
Yes,
you were acting for NPA on the
Yes.
matters that are brought before court out of
Yes.
state capture.
Sorry, I did
Were
get
you
to-
the acting judge? So I'm battling to hear your answer there.
yes, you're quite right. I've gone off on a tangent. The reason I went off on a tangent was that when I left the commission, I wanted to go and apply to be a judge again. But I felt that I was so invested in the work at the commission and I owed a duty to complete the work through the NPA. That work was ongoing. It was literally keeping me busy every single month. And
So you're still in brief currently from NPA?
I'm still currently in brief with the NPA, and hopefully it's going to come to an end. But I've done almost all the preparatory work in that matter now.
Your contract now, it's how long? With the NPA?
No, I'm not on contract.
You're not on a contract,
No.
just, it's a
No,
brief.
It's a brief.
Okay.
It's not on contract.
And
do
you're
have
working
a s-
alone on that brief?
No, I've got a senior on that brief.
Okay.
But
You'd understand my concern from where I'm sitting as a Minister of Justice.
yes, I understand your concern, but I've got a senior in the brief, I'm in the brief, and there's a second junior in the brief. We've worked together on it for a very, very long time. I think it's about to go to a conclusion, but I was concerned that I've waited since I got back from the commission in 2021. I've actually waited 4 or 5 years, and I was concerned that actually if I keep waiting until this goes to finality, every year I'm going to get older, and the older I get, the more I'm going to get an answer that you're actually too old now to be appointed a judge. And I want to avoid that, because I would really love to be a judge.
Thank you, CJ.
Thank you, CJ. Good afternoon.
Good
Yes,
afternoon,
I'm this side.
Commissioner.
I'm this side. Okay. Thank you very much. It's Commissioner Marumu Wakai. I was looking at your CV, and I was convinced that perhaps maybe discussions relating to mercantile law will be worthwhile with you. That mercantile law is your area of specialization. Different parts, company law and intellectual property.
Yes.
Yes. I had a chance to read your judgment,
Yes,
United Manganese of Kalahari, that was taken to the Supreme Court of Appeal.
yes.
And it was an interesting read. And from that judgment, I just want to ask you, because I've also read the Supreme Court of Appeals judgment also.
Yes.
I just want to know, what is the actual role of good faith in derivative action applications? And in answering that question, I just want to find out whether your view has changed in light of the Supreme Court of Appeals decision in relation to the minority shareholders in terms of Section 165 of the Companies Act, whether they bear the onus of proving the absence of collateral purpose as a self-standing requirement of good faith inquiry when they seek to bring this action to protect the interest of the company.
Yes, thank you for that question. It's something that I deliberated on a long time, and I looked at a lot of international law, and I think if I remember, I looked at Australian law as well. And I obviously at the time believed, yes, I've come to the right conclusion. But when I did read the judgment of the Supreme Court of Appeal, I think they are correct on the onus. I think I got it wrong.
No, thank you very much for that. My second question to you is, many people are starting businesses in townships and in villages, and most of them do not even worry about the intellectual property sort of protections that can actually arise from what they are starting, from protecting their names, protecting the goodwill, and everything else that comes with IP. I just want to get a sense whether, and obviously sometimes you find yourself having a company in the Northwest, and all of a sudden you get a letter from a company in KwaZulu-Natal where they say, you are using our name incorrectly, we want you to change your name and all those things. I mean, the company's tribunal is inundated with those kind of applications. I just want to know, and sometimes these are companies that are trying to protect their names, but they are not registered, those names. And you find that both companies' names are not registered. And the other one is saying, no, my name is a trademark and I've been using it for quite some time. Sometimes it's part of the surname of the family where they come from. I just want to know, in South Africa, is it possible to protect an unregistered trademark? And if so, under what circumstances?
Commissioner, to be honest with you, I haven't done an intellectual property case for several years. But as I recall it, if your trademark is not registered, unless it can be shown that you are passing off that name as the other corporation or entity's name, I don't think there is relief. And I'm not sure if you are in a village and you are not even aware that there is this other entity that is using your name, how you can possibly be found to be passing off.
In fairness, I should not take it further because I thought these are things that you are doing on a regular basis. But passing off is an extra thing that deals with unfair competition. So just from a common law perspective, I was just looking at it from a statutory point of view. But nonetheless, I won't take it further. Thank you very much. Thank you, CJ.
Thank you.
Thank you, CJ, and good afternoon,
Thank
Advocate
you.
Wentzel.
Thank you for putting up your hand.
Yes, I'm sorry to take you back from what you just discussed with the minister.
Yes.
Yeah, and it relates to separation of powers and the current position relating to the judiciary and the prosecuting authority.
Yes.
The other being part of the executive.
Yes.
And the impression that might be created might be that you are working for the NPA. Now, if you could just explain the nature of your relationship with the NPA and the kind of work that you were doing. For example, I want to establish whether you were working with dockets, getting involved with police officers and taking decisions on prosecutions, or were you still independent counsel, accepting or doing work for the NPA, receiving work from the NPA and taking independent decisions on professional basis?
Yes. The work that we've predominantly been involved in for the NPA is running disciplinary inquiries. So we haven't been involved in the criminal work of the ID. But if I understand it, and I believe I'm correct, is the nature of disciplinary inquiries are confidential. So I feel a little bit constrained to tell you what the nature of it is, but it's not criminal. It's internal disciplinary inquiries within the National Prosecuting Authority.
Your appointment was not the same as the appointment for prosecutors and people who take decisions to prosecute?
No, we've not been involved in that at all. That work is all done through the state prosecutors who are appointed by the ID.
I see. And then when last did you have this engagement with the state attorney? I mean, with the NPA?
It's been ongoing. So what has happened is obviously there are delays. So we do some work, then a few months go by, and then we get briefed again to do some more work, and then another period elapses, and we get briefed again to do more work. So it's just been an ongoing matter in that respect,
On the basis of the briefs that you received.
on the basis of the briefs that we received.
Thank you. Thank you, Advocate.
Thank
you,
you.
Chief Justice.
Thank you, CJ.
Minister is a
My apologies,
call it just
CJ.
now.
I'm confused, Advocate Wentzel. In IDEC, the work that they do in relation to state capture,
Yes,
it's very clear.
yes.
Now, I'm confused about what you are saying to the answer to DJP.
Okay.
JP Tlalets, my apologies. My apologies.
If I can,
Yeah, I'm a bit confused.
okay, sure.
Because when I asked the question, that's why he did a follow-up.
Yes,
And I asked you, are there matters that you're dealing and you understand my concern? Hence, I asked you about your involvement in NPA and acting judge. Your answer to me was that you pulled out of being the acting judge. You've not been acting. You've been focused on the work of NPA. And I asked whether you're working alone. You said, no, you've got a team that you are on brief on. That's why I asked, are you on contract? Because I wanted to determine
No, we're not
whether
on
you
a
are a
contract.
Section 38 appointment or not. And that's the context I'm asking now. Your answer to the last question leaves me quite worried and hanging.
okay. If I can understand what worries you is that there's no conflict whatsoever between the work, the disciplinary inquiries we've been insisting with in the NPA and the prosecutorial work that the NPA is doing. So the ID is briefed to prosecute matters that have arisen from the state capture inquiry. But our focus has been on disciplinary inquiries within the NPA, which have gone on for a very, very long time. There have been enormous amounts of delays, and they are not yet finalized. But it's gone on so long that most of the people who were being disciplined have already left the NPA and have retired.
No, maybe let me clarify. IDEC was established in 2024.
Yes,
The disciplinary will not be in IDEC, but directly with NPA, because those will be employees of NPA, not in the IDEC. Because this work of IDEC is more around fighting corruption and
Exactly.
organized crime.
exactly.
So because they are employees of NPA,
Yes,
the corporate services will lead on disciplinary measures, not IDEC. That's why I got confused about why you're referring. And the reason why I got concerned is because your reference to IDEC is because of the mandate of IDEC in terms of its work within NPA. Now, if you are working on disciplinary, it can't be within IDEC.
no, it's not
It will-
within ID.
Yeah, that's what confused. So your reference, maybe clarify then your reference of involvement of IDEC.
No, it is, the work that we're doing is not for ID. Our brief is coming from the NPA and particularly the Human Resources Department of the NPA. That is who our brief has come from, through the state attorney, of course. So they have engaged the state attorney to brief us. The disciplinary inquiries, and this is where I'm saying I'm feeling, it's difficult for me to tell you the nature, but there were allegations that were made at the.
You don't have to go into
Okay.
detail. That's why I was saying, what you led us to be confused.
Yes.
It's your reference to IDEC.
ID.
Because
I
of the
understand that.
mandate of that organization.
Yes.
Thanks, CJ.
I understand. I'm sorry for that confusion.
Commissioner Matolo Tlhephe.
Thank you, CJ, and good afternoon, Advocate Wentzel. Good afternoon.
Good afternoon. Sorry, I'm just finding it hard to see who's talking to me.
Okay.
Oh,
Y-
thank
y-
you.
You know, when I looked at your CV and your questionnaire, I got excited that you are serving on the briefing patterns subcommittee and the transformation committee. But whilst you're talking, I got worried that you don't seem to understand what these committees are doing. Can you just maybe give me comfort that you tell me what you do in this committee? Because for me, whilst we're talking, it's as if some people were doing it, not you. I need to understand what they
No,
do.
we were meeting on a weekly basis. And everybody was coming up with ideas and how are we going to fix things? What are we going to do? How are we going to be proactive? So on those committees, it is, so at that stage, the project that we were following was trying to approach the banks to try and see if we could give them schedules of previously disadvantaged people to brief. And then they have certain attorneys who get certain amount of the work, and they were instructing those attorneys to please brief the people on the list. And they were reporting back to us as to who had been briefed on the list. So it was a way of trying to assist previously disadvantaged members of the bar in getting work. Because as we all know at the bar, you start your practice doing divorce work, unopposed motion work, and noting a judgment. But every one of those matters is important. And the reason they're important is because they're an introduction to an attorney. So if you can get a bank to say, I want you to make sure that of the briefs, so instead of sending all your briefs for default judgments to one attorney who briefs one advocate who sits with 50 briefs, which they move on the one day. What we were trying to achieve was that work would be spread out. And if they could brief from the list, then every single one of those advocates who then got a brief from the list, they now got an introduction to a new attorney. And that was a way of, you get introduced to an attorney, they think, oh, I like that person. I need to note a judgment. I'll phone them and ask them next time. Or, I've got a small trial. Let me phone them and ask if they can do it. It was a way of seeing how can we make a difference.
You have been in practice for 36 years as an advocate, am I correct? And how many black juniors have you led? Especially females?
I think now I've had 5 or 6.
For 36 years?
Pardon?
For 36 years in practice?
Yes, but that's what I was trying to explain to you, that actually in the way that my life went, and I think I omitted to say to you also that before I went to the commission in 2014, my husband died. And he died in horrible circumstances, and he left us with an enormous amount of debt. And I had 3 small children. I was completely shattered. And I had to support my children. I had to put my head down. And unfortunately, in those years, my life was inward looking. But the minute I got myself back on my feet, you will notice that I've taken every single possible step that I can to try and get black juniors. And the first opportunity I did, I paid for that junior myself. And the other thing is recently now, I'm a member of AFT. A few months ago, I got a request to pay a contribution towards pupils at the bar who are struggling to make ends meet. I didn't hesitate to make that contribution. So I know I haven't done as much as I should have, but I've actually, things have been a little tougher for me, but I've done what I can, and I continue to do what I can.
Are you still a member of this committee?
Of AFT,
Yeah, no, of Group 1.
yes, I am.
I come to Group 1, I think on 2 occasions. I haven't met you actually, talking to the Transformation Committee. Well, are you really active in this group?
I'm active in that group, but I'm no longer on the Group 1's Transformation Committee.
Okay. Thanks, CJ.
President Moleman.
Thank you very much, Chief Justice. Good afternoon, Advocate Wentzel. This is just a follow-up. I'm following up. I'm over here, ma'am.
Oh, sorry, I don't know. Do you know, when I had that stroke, I've lost my directional hearing. So I
Okay.
actually don't know from which side of the room the sound is coming.
Okay, that's fine.
Sorry.
Yes. How are you?
I'm fine, thank you.
Thank you. I'm just following up on the question that was posed by Commissioner Matolo to you. So I just need clarity. Could you please just clarify this for me? Are we at a stage where we can say that the issue of skewed briefing patterns has now been addressed and it's now a thing of the past? Or is it something that is still ongoing? Thank you.
Commissioner, the issue of skewed briefing patterns is nowhere close to being something of the past. And I'll tell you that I have felt it very keenly as a white woman trying to compete with white males in a commercial field. I will tell you that it's even harder for black males in the commercial work to try and compete. It's even harder and much worse for black females. Not that there are not some very successful people who have achieved it. But what I did get the sense when I was on the Transformation Committee was talking to the people who were really trying their best just to break in. And the problem with the bar is it requires someone to give you a leg up. So if you go to the bar and you join a group and somebody says, okay, let me help you do this, I'll try and do that, it gets you that one step further. But unfortunately, firstly, the bars become enormous. People don't really know each other properly anymore. And that's why I think you have to have some kind of system in place. That's why I thought of the pupillage system in England, because then the work comes to the group, not to the individual advocate, and then it gets spread out. But it's very, very difficult to address that, because so much is also luck that you manage to get a good mentor, and another is that people just continue to struggle. And the worst thing is that although group fees are subsidized, if you're not getting any work, it doesn't matter that your room is costing 5,000 Rand a month, because you can't pay for it. So it's far from being addressed. There's a long way to go.
Thank you for that clarification. Thank you, CJ.
Commissioner Shivan.
Thank you, Chief Justice. In the review of your application by the General Counsel of the Bar, they stated that you had 3 judgments they found that were delivered after 5 months, 1 after 5 months, 2 after 5 months, and 1 after 4 months. Before I get to that, do you know the average time the time, the recommended time within which judgments must be
Yes.
delivered?
I'm not sure which of those judgments that they are referring to, so it's hard to address it. But I know that there is now a rule.
Sorry, I can cite the judgments. They've cited it if you
Oh,
want
have
me
they?
to.
Yes.
It's M versus S. It's 2018, and it's Johannesburg High Court.
Yes.
They have 19 April 20, I think, I don't know if that was the hearing date. 19 April 2018. Then Kahalo versus Road Freight and Logistics Industry Provident Fund. They dated 19 April 2018, 5 months. And TABK versus LVK, JDR Johannesburg High Court, 4 months. 2023 case number.
Okay, the last one I recall, and it's the matter that involved the interpretation on the Adoption Act and whether a foreign couple could adopt a young boy. And that matter took me a long time because firstly, I wanted to see the child, which I arranged. And then after it, I deliberated and changed my mind and deliberated again because it was a massive, massive issue because these were Polish people who wanted to apply to adopt a little boy that they'd looked after since he was a baby. They'd been in South Africa for 5 years, they'd moved back to Poland, and they were applying now, not as residents, to try and adopt this boy and take him to Poland. So that one, I know I just really struggled to come to a conclusion. To be honest with you, I can't remember the reasons for the other two judgments, but I know there's a rule that you must give a judgment in 3 months, and I will generally give a judgment in less than 3 months.
Thank you. What was your ruling in the case that you said, the Polish adoption case that took you 5 months? What was your ruling? 4 months. Sorry. What was your ruling?
Okay. So what the argument was is that the High Court didn't have jurisdiction, and because they, not being residents, also had no jurisdiction to approach the High Court. And because there'd been a decision by the Department of Social Work that the child was not adoptable because there was an aunt in the country who was available to adopt him. Therefore, they couldn't go to the adoption court. They then approached the High Court to say, please allow us to at least have the matter heard in the High Court. I finally decided that they were entitled to bring an application to the adoption court, where it would then be, I gave a ruling on what I understood by adoptability, and the ruling that had come and had been made by the Department of Social Work was that it was based on policy of the department. It wasn't based on legislation. So I felt comfortable that I could say no, that wasn't going to be applicable, and they were entitled, all I declared is they were entitled to approach the children's court to apply for this child's adoption. But I have seen that leave to appeal has been granted in that matter. I haven't seen anything further as to what has been decided, but I have seen that leave to appeal has been granted.
Thank you, Chief Justice. I'm done.
Inkos.
Thank you, CJ. Afternoon, Council.
Good afternoon.
I have heard your response, in fact, many responses on the issue of you leading other councillors in your 35-year period. I don't doubt what you have told us, but take into consideration that you passed your LLB degree with cum laude to one of the best universities in our country. Is there any reason that you could not attain silk besides what you have told us?
Commissioner, you put me in a difficult position because in my view, I am worthy of silk. In my view, I've been worthy of silk for several years. And I don't understand why I haven't been given silk. I actually feel that I've been treated unfairly. I feel I deserve it, but it's unfortunately not in my hands. I can apply and I'm either afforded silk or not. But I do think I'm worthy of silk.
No, thank you, Council.
Thank you.
You produced about 29 judgments.
I actually saw 49.
49.
Yeah.
Thank you. 49 years, yes. And only the 29 that were reported fed through safely. But you say about one that had been reported in the law reports, if I understood your response to CJ's question
Yes.
on this regard. Why?
Part of it, I think, is firstly, I think that reported judgments should really only be judgments that introduce novel areas of law. I have written judgments which I have thought might be reportable, but to be honest with you, when you're an acting judge, it always seems to me a little arrogant to mark your judgment reportable. So even the judgment that was reported, I was approached by the librarian and they said, we'd like to report your judgment. Would you like to review it? And I said yes, and they reported the judgment. I think if I was appointed a judge, I'd feel more confident to say, yes, I think this should be a reportable judgment. But I think while you're an acting judge, I think it's a little assuming.
Thank you. Lastly, as a senior junior, and you know that you are capable of leading other juniors. You seem to have led very few.
You're correct.
Yes, and is there any reason why?
I'll tell you why, is that very unfortunately, as I tried to explain, what happened to me is that I first went back after spending a few years at home with my children. As soon as I went back, I got sick. At that stage, I had lost my attorneys. I was then reliant on senior people to be their junior. Then what started to happen is, as I got older, I got involved in more, even larger commercial arbitrations. But the attorney hadn't briefed me. I was brought in by seniors, and those attorneys didn't brief me on my own. And unfortunately, you can't go and tout at the bar, and you get the work that you get. And even when I started to get the state attorney work, I was trying to bring in juniors, but then the state attorney doesn't want to spend too much money. So they were saying no. But the first opportunity that I got where I said, this is a matter that deserves a junior. It can command a junior. Even then I was told no. And it's only of late that the state attorney is now briefing me in every one of my matters with the junior. But those matters are also ongoing. So my practice isn't that I'm in court 3 days a week. The matters that I'm involved in are going over several months. The one is over 2 years where I've had the black female junior.
Thank you, CJ.
Commissioner Hassan?
Thank you, Chief Justice. Advocate on this side, Commissioner Hassan.
Thank you.
Advocate, I appreciate the context that you've outlined in a great level of detail of how we've gotten to this point. I think my concern is that it almost reads as if you had no agency to confront those entrenched briefing patterns that you've taken us through. Given your seniority and your relative advantages that have been held within chambers over the years and maybe even on the roll, what did you do personally, using what agency you have, to disrupt this exclusionary briefing system?
Well, I've tried to join those committees to see how you can change it. In our group, in Group 1, we've gotten an initiative, obviously, to try and assist the young female juniors in our group through a mentoring program. I've always had an open door policy in my group. Anybody wants to come in, I will try and assist them. But ultimately, the fact is people have been trying for 20 years to change those patterns. They're not easy to change. And I've done what I can within the realm of my practice and having regard to the nature of the briefs that I've got.
All right, thank you, CJ. I think you've also, through other questions, answered some of my follow-ups. Thank you.
Thank you.
No more questions? AJP?
Thank you, Chief Justice. Yeah, Advocate Wentzel, as we were busy interviewing you, you indicated that the stroke that you had has got an impact. Did you say on your vision or on your hearing?
My hearing.
On your hearing.
But it's just, I can hear, but it's directional hearing. So if my cell phone rings, and I don't know my bag is here and it's in my bag, I'm not sure if it's ringing here or if it's ringing here. So it's not an impairment that I've ever had a problem in court that I can't hear counsel, or because I can see that person standing there, that person is standing here. But in a room like this, it's more difficult for me to see where is the person speaking to me.
Also in court, it does not have any
It doesn't
impact.
have any impact at all in a courtroom.
Thank you, Chief Justice.
We've reached the end of your interview, Ms. Wentzel.
Thank you very
Thank
much.
you very
I'm
much.
indebted to everybody for the opportunity.
You're excused.
Thank you.